Good afternoon, and welcome to McGuireWoods' annual Supreme Court term preview for October term 2023. We're excited that you're here with us today. We're excited to be here with you, virtually anyways. We've got a great team of lawyers from our appeals and issue practice from across the firm, all former clerks of the Supreme Court, and excited to share with you a little bit about what's coming this term from the court. Just before we get started, some housekeeping issues. You have all had a chance to submit your CLE information when you signed up for this event. We do have CLE credit for you. There's no code, there's no secret word. Just stay on and enjoy the content, and we'll get an email from us later with the CLE information. We do have a slide at the end for question and answer, but we would really prefer that you submit your questions as we go. We find it makes for a more interesting presentation and discussion. And so you should see on your screen a Q&A tab. Please feel free to submit your questions to us throughout the presentation. Those are anonymous, and we will take them up and answer them as we can. So diving right into the presentation here. Introduce myself and let my colleagues introduce themselves. I'm Jonathan Ellis. I am a partner in our appeals and issues practice. I work out of the Raleigh and DC office. I'm co-chair of the appeals and issues team. I'll let my colleagues introduce themselves, starting with Katie.
Hi, everyone. My name is Katie Barber. I'm an associate in the firm's Richmond office in our appeals and issues and business and securities litigation groups.
Hi, everyone. My name is Jack White, and I'm a partner in our Washington, D.C. and Tysons, Virginia offices. And I too, am a member of our issues and appeals team, and I'm a part of the government investigations and white collar practice.
Good afternoon, everyone, or good morning to those on the West Coast. I'm Brian Schmalzbach. Along with Jonathan, I'm one of the co-chairs of the McGuireWoods Appeals and Issues team, and I practice in the Environmental and Mass Tort Department.
Great. So this is a term preview, but we always like to start with a look back on the previous term, just a few of the highlights. Last year, the court decided issued 56 majority opinions in argued cases, quite a low number, historically speaking, and in line with the recent caseload the courts had. It had one summary reversal and one dismissal, one dig of a case that it decided not to decide after hearing argument. The biggest cases of the term, you'll recall last year, came probably in the affirmative action area with the Harvard and UNC cases. There were also big voting rights cases in Milligan and in Harper v. Moore. There were the student loan forgiveness cases in which the court struck down President Biden's efforts to forgive a large amount of student loan debt. And there were some religious liberty cases, as always seems to be, in Groff and 303 Creative. The pace of decisions last year was remarkably slow at the beginning of the term, perhaps a consequence of the historic leak at the end of OT 21. While the first opinion of most terms is issued in November, sometimes December, we didn't hear anything from the court last year until January, and so we'll see if that repeats itself this year. The court did manage, though, to finish its work and issue all of its opinions before the end of June, before they went off for their European vacations and teaching gigs and whatnot. Taking a step to look at some of the statistics from last term, I think it's fair to say that what last term reflected was sort of a reversion to the mean in many ways. In OT 21, we saw historically low unanimity and substantially increased close cases. Last year, both those numbers were much closer to the recent historical trends. Indeed, if you look at the splits by ideology, think of based on the appointing president, it went from 14 ideological splits in OT 21 down to 5 last term. And I think if you step back from the numbers and statistics and look sort of quantitatively or qualitatively rather, I think that's evident as well. You recall from the end of OT 21, we of course got Dobbs the Dobbs case in abortion rights. The Jackson case was before that as well. There was a huge Second Amendment case in Bruin, a big administrative state case in West Virginia v. EPA, and several religious freedom cases. This term, of course, last term had its share of big cases and monumental ones. We don't mean to diminish that, but the court also went out of its way and voided some of the more controversial rulings. Allen v. Milligan, which I already mentioned, the Voting Rights Act case, could have been a lot bigger than it was. Harper v. Moore, the same. And Google v. Gonzalez, the court literally decided nothing about CDA 230 after hearing argument and avoided a big constitutional ruling in Holland v. Brackeen. So it really was kind of a reversion to the mean in many ways and a much less controversial term. But I'll stop the monologue now and let my colleagues pipe in and see if they have any other views about last year's term.
Yeah, Jonathan, I'd like to briefly look back to this slide where you really see the impact over time of President Trump's appointments, where in 2016, that's the first term without Justice Scalia, where the court was very careful to try to decide many cases as narrowly as possible. You would see cases like Spokio v. Robbins, where the court granted cert to address an interesting question of Article 3 standing and its interrelationship with statutory damages, and ended up issuing a very narrow opinion. And you saw a lot of cases like that. Then Justice Gorsuch is confirmed in April 2017, near the end of that term. The next term, you see a slightly smaller volume of unanimous cases. Justice Kavanaugh confirmed in October of 2018, the next term, again, fewer unanimous cases. And then Justice Barrett confirmed in October of 2020. So you see, as the Trump appointees get appointed and maybe get their feet under them a little bit, you see fewer and fewer unanimous cases, perhaps more votes to grant cert in cases that will not come out in unanimous ways that might invite more of these 6-3, 5-4 decisions. And then, as Jonathan mentioned, in 2021, which was an extraordinary term in many ways, not just because of the leak, but also because of just the volume of high-profile, ideologically split cases. I think last term you saw just a bit of a breather. There are good institutional reasons why it may not be good to have the Supreme Court above the fold on the headlines every week of the year, and I think 2022 is maybe closer to the mean, but going forward we'll certainly have less unanimity than we did in 2016 for the foreseeable future.
Seems right. So one more look at the statistics from last term and about how it all kind of cashed out in the votes. One thing to point out, sort of underscoring what we've been talking about already, is that all three democratically appointed justices saw their frequency in the majority increase last term over the term before. I think of particular note, Justice Jackson, who we'll talk about in just a moment, but found herself in the majority more frequently than Justice Thomas Alito or Gorsuch. And then, of course, the Chief Justice and Justice Kavanaugh continued finding themselves in the majority in the vast bulk majority of the cases that the court decides. Indeed, the Chief was in the majority 95% of the cases, Justice Kavanaugh in the majority 96. And so I guess my question for my colleagues here is sort of, how should we think about this court? Maybe, Jack, you have some thoughts about whether we should think about this as a 6-3 court with a conservative or a liberal ideology. Maybe it's a 3-3-3 court, or maybe it's the Chief Justice's court or Justice Kavanaugh's court. What do you think, Jack?
I think the jury is out. I think that, and I'm sure we'll talk about this a little bit later, we're seeing how this court is settling in. I think a point to note is in the past several years, we've seen new justices on the court. But when a justice comes to the court, that's not just one person coming, it's an entirely different court. The order of voting changes, the order of speaking in conference changes. And so with Justice Brown Jackson coming, we not only have a new person on the court, but the order, because of where Justice Breyer was in the order of speaking. All of these things matter, and now that we're sort of settled in, I think this coming term is going to give us a better sense. Some of the cases on the slate will show us new and interesting alliances, but I get back to where I started. I think the jury is still out, and it remains to be seen, although we're going to settle in this term and the next.
Great, thanks, Jack. And I think that's a pretty good segue to the next thing we wanted to flag and to talk about before we dive into the cases for this coming term. As Jack alluded, we did have a new court last year. Last term was the first term with Justice Jackson replacing Justice Breyer on the court. Recall, she came in right at the end of the OT21 after Justice Breyer announced his retirement and stepped down at the close of that term. Mrs. Jackson was a former law clerk to Justice Breyer. She was also of note a former public defender, a former district judge, and a former circuit judge. And so, in some ways, folks, I think, might have reasonably thought that her addition to the court was maybe not as monumental of a change than perhaps Justice Gorsuch's entrance or Justice Barrett's and their replacements. But it really was a new court, and I think there are still some dynamics to figure out. One thing that's been interesting to watch the new justice this term and seeing how she settled in to the court was that her behavior was someone unlike other junior justices. She certainly was not timid coming out of the blocks. She was an active questioner from the bench. She asked more questions and spoke more words from the bench than any other justice last term. She spoke more words than any other justice in the affirmative action cases, in 303 Creative and Moore v. Harper, and in others. She also is a prolific writer. She wrote 5 majority opinions last term and 6 dissents, and those dissents were not short. They averaged 5,300 words, more than any other justice other than Justice Kagan over the last few years. And I think perhaps most interestingly, she wasn't afraid to go out on her own. She issued 3, so half of her dissents last term were solo dissents, which is pretty unusual for a junior justice to strike out like that on their own. And that included not just those 3 dissents on an argued cases. She also issued several dissents on the orders list as well, sometimes solo dissents. And she wasn't afraid to vote in ways that maybe weren't expected of her. She and Justice Gorsuch teamed up on a couple of different occasions to issue interesting decisions in cases, even though some might think of Justice Jackson and Justice Gorsuch on the polar opposite ends of the court as far as the ideology goes. So let me stop there and again bring in my colleagues. Katie, what do you think about Justice Jackson's first term? Any thoughts on why she approached it perhaps the way she did?
Well, I mean, I agree that it's notable that she approached it the way that she did, including because it's so different than how Justice Breyer operates on the court, I think. Especially going out on her own. Justice Breyer is often working for, unanimity, for having joined her to his opinions, and it's also just different from how junior justices usually kind of approach coming onto the court. Hazarding guesses as to why that might be. I mean, I think her background, having spent most of her judicial career so far as a federal district judge, she's used to running her own courtroom and being the only person speaking from the bench, and so there's probably a comfort level there. And then too, just the dynamics of the court she's coming into. She's coming into this minority of 3 liberal justices, and just as the right side of the court is not a monolith, the justices there kind of approach their judging in different ways. I think too, she's showing that the 3 liberal justices have their own kind of ways of approaching issues, and she doesn't necessarily have anything to lose by going out and staking out her position on these things. You commented, Jonathan, that people didn't necessarily think for this to be like a monumental shift to the court, right? And maybe not in in the immediate. But hopefully Justice Jackson is on the court for a long time. And I think there may be an element where she's kind of writing for the future. She's writing for how she thinks the law should be and maybe will eventually be. So I think all of that could maybe play into how she's kind of jumped in head and feet first into her first term.
Yeah, one thing that's very interesting about Justice Jackson is I think you have to go back a long ways to find a justice as active from the bench on his or her first term, all the way, I think, to Justice Scalia, who, when some of the justices' retirement papers came out, it was revealed that on the bench, Justice Blackmun remarked to a colleague when Justice Scalia was, leading one of his famous long dialogues, if it's fair to call it a dialogue rather than a monologue. And Justice Blackmun said, "Do you think he even knows the rest of us are here?" Not at all that that's what Justice Jackson is doing, but it was noticeable that she and Justice Scalia both made that kind of an impact in their very first term on the bench.
Great. Well, it'll be interesting to see how this term unfolds and how Justice Jackson, her style and approach to the bench evolves. So let's dive in now to the cases the court is going to hear or has already heard this term. Jack, you want to talk about the CFPB case?
Sure. And as you mentioned, this is one that was heard a week ago today. It is styled CFPB versus CFSAA, and as a former military guy, I am now allergic to acronyms. So it's the Consumer Financial Protection Bureau versus the Consumer Financial Services Association of America. And we start our review of cases looking at a case that is a direct challenge of constitutionality. Here, we're looking at Congress's spending powers. So by way of background, in the midst of the financial crisis of 2007, Congress passed the Dodd-Frank Wall Street Reform and Consumer Protection Act, which created the CFPB. And the CFPB was tasked with, among other things, writing and enforcing rules for financial institutions. 10 years later, in 2017, the CFPB adopted a rule regulating payday lenders, specifically prohibiting lenders from further attempting to withdraw funds from borrowers' bank accounts after 2 consecutive attempts failed for lack of funds. Now, the lenders challenged that not squarely on the legitimacy of the regulation, but rather arguing that the funding scheme of the CFPB is unconstitutional. So their specific argument is that instead of receiving money allocated to it each year by Congress, like other agencies, the CFPB receives funding directly from the Federal Reserve, which, as we all know, collects fees from its member banks. The district court found that this was not unconstitutional, but the Fifth Circuit disagreed, finding that that type of appropriation was indeed unconstitutional in violation of Article 1, Section 9. So the issue is whether Congress can allocate funds the way that it did to create the CFPB without violating its spending powers. And the argument was rather interesting because we had 2 solicitors general warring, the current Solicitor General and the immediate past Solicitor General, Noel Francisco. During the argument, the current Solicitor General, on behalf of the United States, analogizes this to other instances like the U.S. Customs Service and the U.S. Post Office. And the former solicitor acknowledges that this is a spending power issue, but warns that open-ended funding, unchecked by political control, because of the manner in which the funding exists coming directly from the Federal Reserve, could disrupt separation of powers between the branches of government. So this is an interesting one and curious to see the direction that the court takes. Our prediction is that the Fifth Circuit's ruling will not stand, but the how is a bit of a challenge.
Katie, were you able to watch the oral argument? Any thoughts from you on how the court's going to approach this one?
Yeah, I mean, I think the oral argument, it, in my view, did not go particularly well for Mr. Francisco and for the challengers to the CFPB. Of course, you can't, we always hesitate to read too much into oral argument, but there seemed to be skepticism even from members of the more conservative wing of the court to the challengers' arguments, and also some confusion about exactly what the basis of the challenge was. I mean, also kind of emphasizing that how well it was not going for them was, I think, Justice Thomas, an hour into argument, asked Noel Francisco, can you finish this sentence for me? The CFPB's funding structure is unconstitutional because, reflecting that maybe he was also confused about exactly what was going on. So as we note here, like the appropriate remedies for finding that the funding structure is unconstitutional are interesting, but the court did not even get to that question. And so I think the argument at least seems to indicate that the CFPB may be okay for now.
And just one last point. One of the things to demonstrate how Katie says the argument was not going well for General Francisco is at one point he countered to Justice Thomas that Congress could create a valid appropriation for the CFPB, making clear that prior rules and regulations were still good law. And the challenge there is that that would not fix the underlying problem with regard to the regulation that caused this appeal in the first place. So it's going to be very interesting to see how this one turns out.
Well, so perhaps the CFPB will live to fight another day. I guess let's turn to see if the federal government's most potent federal criminal statute is going to survive a constitutional challenge. Brian?
Not to play spoiler, but I think it will. Rahimi is the fourth case in the modern line of Second Amendment cases, starting with Heller and then McDonald and then Bruen. It's actually much more. Bruen and Rahimi are much more than just Second Amendment cases, though, for reasons I'll explain in a bit. What Bruen did was Bruen looked at a New York statute that said concealed carry permits may be issued, but were not required to be issued, and that left a lot of discretion in whether to issue them or not. But what Bruen says is we're going to evaluate the constitutionality of New York's restriction and all Second Amendment related restrictions going forward, not using the traditional method. The traditional constitutional method that we all learned in law school and we all studied for on the bar is that we look at means and scrutiny. We look first, is there a right? Second, was it violated, of course. But that's not the end of the analysis. Under the traditional strict scrutiny or intermediate scrutiny test, we would ask, well, even if a right was violated, did the government have a really good reason to violate that right? And if it had a really good reason, was the violation narrowly tailored to that really good reason? At least for the Second Amendment, Bruen throws that all out. Bruen says we're not going to do means and scrutiny, at least for the Second Amendment. Instead, we're just going to ask two questions. Is the right covered by the scope of the Second Amendment, which Heller says is pretty broad, pretty categorical? And then second, is there some well-established historical analog that would let a government regulate that right? So the right at issue here is gun possession, And Mr. Rahimi, unlike all of the other litigants who brought these Second Amendment challenges in the recent cases, Mr. Rahimi seems like not such a nice guy. He assaulted his girlfriend and then started firing his weapon at various people who saw him do so, or might have seen him do so, or might have testified against him in a future proceeding. And that ended up with Mr. Rahimi being subject to a protective order. And that protective order is the sort of thing that under 18 U.S.C. 922 G8 bars him from possessing a firearm. And so the question as it comes to the court in Rahimi is, does Section 922 G8 violate the Second Amendment as it's applied to people who have been hit with a domestic violence protective order? What this case is really about is part of Heller and part of the Second Amendment history that deals with dangerous people, non-law abiding people. Heller says that everyone is entitled to the protection of the Second Amendment, but it has this carve out for those who are not law-abiding responsible citizens. And so the question in Rahimi is, how do we define what a law-abiding responsible citizen is? What are the historical analogs that would let a government regulate possession of a firearm by someone who may not be considered a law-abiding responsible citizen? How strictly do we look at that? Bruin, as I suggested, is really a very different approach to constitutional litigation. And so there's a ton of open questions in Bruin about what level of generality do we use when looking at historical analogs that would allow regulation of firearms possession. Bruin is just one case, and it addressed just one New York law, but there's a ton of these questions that apply to all sorts of different federal and potentially state firearm possession restrictions. You can tell from 922 G8, there's a bunch of different federal restrictions, and so this case is seen potentially as the first or second in a long line of litigation that will be needed to determine whether all of those restrictions are valid. I think that this is going to be a relatively easy case for the United States. I think it's going to be very, very difficult to find 5 votes for the proposition that people who have already been adjudicated in a procedure like Mr. Rahimi was afforded to be an imminent threat to a girlfriend, a wife, a child, someone who lives in your house, that person can't be prevented from having access to a weapon when there is a fair amount of evidence that adding firearms to that mix of violence can result in bad outcomes for everyone. I think the easy way out of this is a historical line of statutes called surety statutes, which allowed a government to put restrictions on the right to possess or to carry firearms if that person was seen as an imminent threat to another individual. And at that point, a court could require the person to post surety, to essentially post a bond to buy back the right to carry that firearm. I think there are going to be 5 votes to say that's close enough to what 922 G8 does to allow the federal government to restrict possession by people subject to domestic violence protective orders here.
Thanks, Brian. So, Jack, I'll just turn to you. I mean, I think Brian has offered one narrow way that I think fits fairly comfortably within the Bruin framework. The government's brief in this case, I noted, doesn't really stick to that approach. It makes a much broader argument about really giving some historical heft to the law-abiding and responsible citizen carve-out that Brian mentioned from Heller. I wonder, do you agree with Brian? Is the court going to resolve this and fit it within the Bruin framework, or will it backtrack and maybe expand a little bit the Congress's ability to regulate in ways that would affect others' Second Amendment rights?
Well, I looked at the government's brief, and I think it goes a little further than we be willing to do. I think that in Bruin, they were seeking some degree of objectivity, and notwithstanding what Brian points out, they have I don't want to use his word surety, but they have a degree of security in an approach. I think what they're going to do is kind of add some more flesh to Bruin and how Bruin should be applied. So I agree with Ryan. This case is almost too easy to expand Bruin much, but I think they will give some guidance to avoid some of the confusion that exists in applying Bruin.
Great, thanks, Jack. Well, moving from the criminal back to the administrative state, Katie, why don't you tell us a little bit about the challenge in SEC v. Casey?
Sure. So this is another challenge to the administrative state. We already talked about the CFPB case. We're going to talk about the Chevron case in a little bit too. So this is another admin law case with multiple complex constitutional administrative law questions raised. So it centers on the Securities and Exchange Commission and the way that SEC enforcement proceedings are structured. So the SEC basically has broad discretion to decide at the outset of an enforcement proceeding whether it's going to bring that enforcement proceeding in its own administrative proceedings or in a federal court. It typically brings it in its own administrative proceedings. In those proceedings, there is an SEC administrative law judge, an ALJ that adjudicates the proceedings in the first instance. And then those proceedings are often reviewed by the commission itself. And then when there is a final order from the SEC, there is a right to appeal to a federal court of appeals. And so the questions in this case, they arise out of an enforcement action against a hedge fund manager who the SEC charged with securities fraud. He was found liable in an administrative proceeding by an ALJ, and there were civil penalties and disgorgement ordered against him. He was also barred from participating in the securities industry going forward. The commission then affirmed on appeal, and then Jarchese appealed to the Fifth Circuit. You'll see the Fifth Circuit comes up a few times in our presentation today. A lot of its decisions going against the administrative state and going pretty much in a pretty extreme direction. So this decision is one of those. The Fifth Circuit held that there were three constitutional issues with the SEC. First, that the SEC proceedings violate the Seventh Amendment right to a jury because they're basically enforcing common law remedies by seeking civil penalties without providing a jury. And then because the SEC has this broad discretion to decide whether it enforces securities laws through agency adjudication or in federal court, that discretion violates the non-delegation doctrine, which is the principle that Congress cannot delegate legislative power to agencies without, or at least not do it without providing some intelligible principle for the exercise of that power. And then third, the Fifth Circuit held that the fact that there is a kind of double for-cause removal protection for SEC ALJs, that is a constitutional problem, violates Article 2's Take Care Clause. So there's, like I said, three kind of complex questions raised in this case, and the Fifth Circuit found that it accepted all of them. I think our prediction here is that the Supreme Court is not going to go as far as the Fifth Circuit did, but there is likely to be some paring back of the SEC's powers, and whatever form that paring back takes is going to have tremendous implications across the federal administrative state. The SEC's structure and powers mirror or have similarities to a lot of other agencies, especially their use of ALJs, for example. There are some 2,000 ALJs employed across the federal system, and that's twice the number of Article 3 judges. So whatever happens in this case, it is likely to have a lot of those ripple effects.
So what jumps out at me at this case is the non-delegation holding, which is a non-delegation holding in the wild, which is something that we really haven't seen much of for decades. Really, you have to go back to the 30s to find rigorous enforcement of the non-delegation doctrine. It does raise the question whether we are ready for a non-delegation moment. You've seen feints at it. Justice Gorsuch in West Virginia, the EPA, he said that one of the ways to conceive of the major questions doctrine is as a way to implement the non-delegation doctrine without applying it directly as a constitutional holding. And I think there might be something to that. And you see various types of doctrines like that, canons of construction that are designed to get at non-delegation values. And whereas for those of you who don't know Katie as well, she said extreme. What she meant was principled application of the original understanding of the separation of powers. I want to make sure that was clear to everyone. But indeed, this was an extreme application of the non-delegation doctrine. And if taken seriously, it would imply that a very common administrative law doctrine called the Chenery Doctrine, also which arose through a case involving the SEC, would be unconstitutional. The Chenery Doctrine, or this Chenery Doctrine, says that an agency generally gets to choose whether it advances its priorities through rulemaking or through adjudication. And I think the Chenery Doctrine would be subject to a non-delegation challenge for exactly the same reason as the agency's decision to pursue enforcement through agency adjudication or Article 3 adjudication. So there's a lot of interesting things going on in this case. I don't think a radical non-delegation holding is what we're going to see at the end of the day. But Katie's exactly right that this does seem to be an opportunity for the court to continue subtly paring back the administrative state, although maybe in a way that will preserve some of what ALJs do, because they are responsible for a tremendous volume of federal adjudication.
So I'll ask it. It sounds like non-delegation maybe is not the way to go. Which way do you think they will go if they're going to further pare back the SEC and the powers and the use of ALJs?
I think the Seventh Amendment will be attractive to the court. The court, not always in cases involving agencies, but particularly in cases involving bankruptcy courts, has been active in the Seventh Amendment space recently. Stern v. Marshall is one recent case that started to move in that direction. So I think there's some recent momentum on the Seventh Amendment side, but obviously some momentum on the removal protection side too, with cases like Free Enterprise Fund.
Great.
Yeah, those would be my expectations as well.
There we go. So we'll keep moving along. Oh, sorry, Jack, go ahead.
Just quickly, each of those would be the least disruptive because there are ramifications to other agencies, and I think the court will be aware of that.
Great. So moving right along, I'll pause here before I turn over to Brian to cover the net choice cases and remind everyone that we'd love to have your questions. We can ramble on for a long time uninterrupted. That's what we do. But would love to answer any questions you have. We do have one that's sort of not on a particular case, but on a topic that we see and we'll address at the end. If you have any questions on the cases we're discussing, please feel free to submit those. But Brian, why don't you tell us a little bit about the net choice cases that were just granted?
Yeah, so the net choice cases are fascinating. They might affect more people than just about anything else that the Supreme Court does this term. In 2021, both Florida and Texas adopted these laws that were designed to push back against what they saw as capture of social media content moderation by folks who didn't share their political viewpoint. And would force social media platforms like Twitter or X and Facebook to take a step back from the way they had been doing what those two states saw as suppression of speech they didn't agree with. So one big aspect of both of those laws was to implement restrictions on content moderation through blocking users or deplatforming them, or even shadow banning them, suppressing posts, suppressing the spread of information that they don't like. The other way that both of those states addressed this perceived problem was requiring individualized explanations when someone is banned or blocked or their posts are removed. And so in both cases, the question is, do those restrictions from state law violate the First Amendment? We had a great, clear circuit split on this. The 11th Circuit actually went first and did not. I'm sorry, the Fifth Circuit upheld the Texas law, said that this wasn't speech at all, what the platforms do when they moderate content, and that the individualized explanation requirement was not that big of a deal. And the 11th Circuit disagreed, making a very clear circuit split. And one of the interesting things that happened right after that, and I know we've had a question about the shadow docket and what the court has been doing there and how it's likely to continue. This case appeared on the shadow docket briefly. The Texas law was initially enjoined by the Western District of Texas, but then the Fifth Circuit stayed that injunction. So the Western District of Texas, the district court, said this Fifth Circuit law is unconstitutional, and it was enjoined. And then the Fifth Circuit said, no, we suspect that the Texas law is not unconstitutional, that it does survive First Amendment scrutiny. But then the Supreme Court, in a 5-4 order, vacated that stay and said that the Texas law could be enforced. So that's both useful on the shadow docket point, showing how the justices continue to be active on the orders list outside of the normal argued merits cases. But it also gives us a really strong hint about the future of this case at the Supreme Court, because we know that there's already 5 votes that suspect that the law will be struck down. A couple of things that I'm looking out for in this case. One actually relates back to a 2021 separate opinion from Justice Thomas, who walks through this very interesting idea that social media platforms like Twitter, like Facebook, are modern day common carriers. So the idea is that a telephone company, for example, is a common carrier and generally has to serve all comers. It can't discriminate against viewpoint or content based on what's being carried over that common carrier platform. And Justice Thomas speculated, or maybe hypothesized in that opinion, that social media platforms, because of their similarities to telephone carriers and because of their significant market control, could constitutionally be treated as common carriers also. And so Justice Thomas joined the dissenters. He dissented from vacating the stay. And so he's probably a vote to say that these laws are constitutional because the social media platforms are common carriers. It'll be interesting to see if he can gather any other votes for that notion and see how that idea develops as this case makes its way through the Supreme Court.
So Jack, Brian has staked out his view. The court's going to uphold these declare these laws unconstitutional. But what do you think? You think Justice Thomas can find 4 more votes for his common carrier view, or is there another path here?
Well, again, I have to agree with Brian on the outcome. One of the things that I find interesting is that this is coming up during, as we're on the precipice of the intensity of an election cycle, and we're seeing more and more use of social media during those cycles. So I like the notion regarding the common carrier theory, and I see Justice Thomas's point. I do think at the end of the day, this might not be the case for the court to completely stake out its position on 203, or 230. But I do think it's going to be interesting what they have to say here. At the end of the day, though, the Fifth Circuit, I do think will be reversed.
So I want to briefly address a great question that came up that asked, are these social media platforms like newspapers in the sense that, no, they're not just carrying other people's ideas, but they're exercising some editorial control of their own? I think that is a position that is made much more difficult by the position that social media platforms take, as Jack mentioned, in Section 230 litigation. So Section 230 of the Communications Decency Act says that in general, if you treat individuals who post content on your website as the authors of them, and you don't decide who gets to post what, then you're not liable when they post. If you're just a conduit, then you're not liable. It's the posters who are the individuals who would be liable. But that's in a lot of tension with the idea that these platforms are exercising editorial control like newspapers. So I think they may have some difficulty succeeding with the argument that they're newspapers based on that sort of position that they've taken. And of course, as Jonathan mentioned, in the Gonzalez v. Google case from last term, the Supreme Court really didn't weigh in much about that, didn't resolve the question about the scope of Section 230. So it's a great question, and really an open question, because there's not a ton yet from the Supreme Court about how Section 230 applies to this sort of platform.
Great. Well, thanks, guys, for that preview. Let's turn back to the administrative state. Katie, you want to tell us about the next case up?
Sure, of course. More admin law for you guys. So this is the case that challenges the court's 40-year-old precedent in Chevron. Chevron deference being the rule that if a statute is ambiguous or silent on an issue, then courts should defer to the implementing agency's reasonable interpretation of that statute. And in this case, the statute at issue is the Magnuson-Stevens Act, which is also a 50-year-old law that deals with fishing and trying to prevent overfishing and promote sustainable fishing practices. As part of that, it requires that fishermen carry observers or monitors on their boats. What the statute does not say is who has to pay for those observers to be on the boat. And so some fisheries here, they're actually herring fishermen involved in this case from, I believe, New Jersey, challenged the regulation saying that, I'm sorry, I'm seeing that my, apparently microphone problem, hopefully that fixes it. Let me know if that fixes it, hopefully. Not fixed. Sorry, everybody. So John, if you want to say hi to someone else, if I can get whatever's wrong on my end.
So I'll pick up while you adjust the technical difficulty. With the ambiguity, or the ambiguity gave rise to this appeal, and where the appeal is leading is to answering the question whether there should be greater clarity to the statutory silence that is created by the statute. But the bigger question that's going on here is there has been a movement to abrogate the strength of Chevron deference that has been going on for an extended period of time. This harkens back to the era of Justice Scalia and how he moved over time. And now we have justices on the court who have openly expressed a negative position toward Chevron deference. It's going to be interesting to see exactly what this court does, particularly in light of the fact that it's going to be a court of 8 deciding this case. Just a matter of detail, the case originally came up on appeal at the DC Circuit and was heard the very week that Justice Brown Jackson was nominated to the court. And although she took no part in the decision, she has removed herself from this case. So it's going to be argued and decided by a court of 8, missing Justice Jackson. And it's going to be very interesting to see where the court or how the court constrains Chevron. I think at the end of the day, constraining Chevron is going to be inevitable, but in what way? So I think that's where it's going to end up.
And one thing I'll know to return to the government's briefing here, I think this reminds me of a case the court heard a few terms ago called Kaiser, in which it considered whether to overturn our deference, cousin of Chevron, that gives agency deference on their view of their own regulation as opposed to statutes. In that case, the federal government came in and offered a defense of our deference, but then emphasized all the restraints that the court had recognized and should recognize on that. So much so, I think, that it's pretty reasonable to call our deference now Kaiser deference. The government in this case brief doesn't do the same thing. It's a full-throated defense of Chevron, but doesn't offer all the same limitations. I wonder if that makes the path a little bit more difficult for constraining Chevron and the path to overrule more likely, or if my co-panelists see it differently.
So one point that just jumped out at me in the briefing on this is that the government's right in that a lot of cases have relied on Chevron over the years, but that reliance really ends a few years ago. For several years now, the court has addressed all manner of agency regulations, agency interpretations of statutes that naturally cry out for the Chevron framework. But instead, you get the court just resolving the case based on the court's interpretation of the statute without even mentioning Chevron. So I think that's a hint that there's a lot of the court that has been avoiding this, but maybe doesn't think Chevron is as necessary as it was once considered, which would make the government's task more difficult in preserving a full-throated application of it.
So we do have a question from an audience member about whether and maybe what effect that LOPR could have on tax regulations promulgated by the Treasury Department and interpreting the Internal Revenue Code. Katie, I hope we have our technical problems worked out. Do you want to take a stab at that question? We can see if we can all hear you loud and clear.
Sure. Hopefully you guys can hear me. I mean, I think the impact is going to depend on. I think yes, the short answer is there very likely could be an impact on those kinds of regulations. It's going to depend on exactly what LOPR says about Chevron and what it does with Chevron deference, and then it's going to depend on what the Internal Revenue Code says to the Department of Treasury about that authority and what kind of statutory authorization or language the Treasury Department is acting on when it issues those regulations. So general answer, yes. Specifically how it would have that impact, I think, would depend on the exact regulation and exactly what happens in LOPR.
Yeah, one of the things that Chevron does is it presumes that when there are statutory ambiguities that Congress has delegated the right to interpret those ambiguities and resolve them to the agency. So in theory, even if the court says we're not going to apply Chevron deference to this statute, Congress could turn around and say, well, we want you to do so going forward because that's our instruction. And so in theory, Congress could say, Treasury and the IRS get authority to issue those rules and regulations, and we are expressly telling you, court, to defer to those Treasury interpretations. But there's also schools of thought that Chevron is not just a statutory problem, not just a historical problem, but a constitutional problem, that it ends up delegating excessive power to agencies to say what the law is. And in that case, I don't expect that the court would go that far. But if it were to go that far, then even an explicit delegation of interpretive authority to Treasury would have constitutional problems and may not be allowed.
Great. Thanks, Brian. Well, we're running short on time, but let's talk about one more case. Jack, I think you were going to give us a preview of the next voting rights case before the court.
Yeah, and given the clock, let me see if I can truncate this. We're in an election cycle. There is a body of law that is complete. Versus the South Carolina State Conference of the NAACP is bringing into sharp focus two lines of cases. One line that addresses racial gerrymandering, and another line that addresses political gerrymandering. What happened in South Carolina was when the state legislature was drawing its districts, its congressional districts, in the area around Charleston, it combined Beaufort and Berkeley counties plus a piece of another county to make a Republican-safe district. And the argument in the three-judge panel below was that this was racial gerrymandering in violation of the law as set forth in Cooper versus Harris. The argument of the state lawmakers is that no, this was all partisan. And Rucho versus Common Cause said that federal judges can't even hear lawsuits that are related, that are based on partisan gerrymandering. And so, even though all of the people who were set aside or who were being put outside of this district were African American, 80% of them were. The argument is that that's just an aside. This was not based on race, it was based on political party. The question here is, because the court has treated these cases differently, what do you do when partisan gerrymandering has such strong racial overtones? And again, this is happening during an election cycle with a court that has demonstrated that it's not afraid of dealing squarely with race issues.
Great. Katie, any thoughts about where the court might go in this one?
I think it's hard to say because that overlap is really, it's difficult to parse, and the court hasn't necessarily done the best job in parsing it. So I'm more just hopeful that Jack's prediction that there is more guidance about that interplay, that proves to be correct.
Well, I suppose we'll see. Well, we are running on the end, short of time here, so let me just flip to our last slide, or at least our last slide before the obligatory question and comment slide, and give you just a little preview of what might be coming down the pike here for the court this term. And this relates back to one of the questions we got, and we've Brian already briefly alluded to, is, is the court likely to continue using the shadow docket? And I think the answer is inevitably yes. The shadow docket is also just referred to as the emergency docket. It refers to the court entertaining applications for emergency relief. It can't stop litigants from doing that, and there are cases where emergency intervention by the court is warranted. And so I think yes, the shadow docket or the emergency docket or whatever you want to call that docket is going to continue to exist. This slide is good evidence of that. Every one of these cases has already made its way up to the court and hit the shadow docket in one way or another. And I suspect we're going to see at least one or two or maybe all three of these cases being granted and heard on the normal docket on being argued, perhaps coming up this term. So I'll just flag them, three of them, before as we close here. The first, of course, is another abortion case with regard to the access to mifepristone. The challenge really is quite a sweeping one, challenging going back all the way to the 2000 approval of mifepristone by the FDA. That order, which the district court, or that challenge, which the district court credited, has been scaled back by the Fifth Circuit and stayed by the Supreme Court. But I suspect the court's gonna hear that one on the merits. Quickly on the heels of Harvard and UNC, it looks like the court may well come back into the affirmative action question. This time with regard to primary and secondary schools. There's a school called the Thomas Jefferson High School in the suburbs of DC that had made a race neutral on its face change to its admissions, but allegedly did so for race-based reasons. That is to strike a different balance and decrease the number of Asian Americans who are admitted to that school. That has spawned a fight that is now at the doorstep of the Supreme Court. And finally, there's been a challenge to an ATF regulation that ATF refers to as a regulation of ghost guns. These are unfinished frames that can be shipped and then turned into firearms, but are not serialized in the way the other firearms are. The district court vacated the ATF regulation. The Fifth Circuit, again, in a familiar story, stayed that judgment in part, and the court stayed it pending cert. But I suspect we'll see a cert petition in that case and may well be granted. So there's plenty of interesting cases on the horizon, in addition to the ones we covered here today. Stay tuned. And of course, if you have any questions about these cases or need help from us, we're happy to provide it. But I think we're over time. So thanks so much for your attention today. Thanks for sticking with us. To those of you that did, and we'll be back next time.